Reeves Immigration Law Group now brings you Immigration Law on Your Side.
Well, kababayan, welcome to another Immigration Law on Your Side right here at PHLV Radio. It's another Wednesday night. So it's Kuya Yo coming from the PHLV Radio Studios in Las Vegas. Maraming salamat po for joining us tonight. And alam mo mga kaibigan, ilang beses nyo nang naitanong ito, kaya nabuti natin ito ang topic natin ngayon. In fact, we got this from you. You sent us this suggestion para sa topic ngayong gabi. Paano ba mag-apply ang isang gustong maging US citizen pero merong criminal record or criminal history? Magandang pag-uusapan natin yun kasi kasama natin si Attorney Eric Welsh of Reeves Immigration Law Group. Mga kababayan, alam niyo naman na permanent residents or green card holders can apply for naturalization or US citizenship after a period of time, say 5 years for most, and 3 years for those who are married to a US citizen. But when the potential applicant has a criminal record or a criminal history, special care must be taken to assess the risks of applying. And there may be options for relief kung ang application nyo ay na-deny. So with us tonight again is Attorney Eric Welsh, partner at Reeves Immigration Law Group, to help us understand this very sensitive immigration topic and to help us navigate as well the application for naturalization when the beneficiary has a criminal record. So for the very first time on Immigration Law on Your Side, let's give a warm welcome and mabuhay kay Attorney Eric Welsh. Magandang gabi sa iyo, Attorney Eric. Good evening.
Thanks, Johan. Great to be here.
Wonderful. Awesome. So we're going to start off the question right away. A lot of people, a lot of our kababayans would like to apply for U.S. citizenship, and along the way, within the 5 years that they are here in the United States, some of them would probably hit some potholes and get some criminal record on their name. How does a criminal record affect naturalization, the application for naturalization?
That's a really great question. So there's two ways primarily that a criminal record can affect an application. First, one of the requirements for citizenship is to prove good moral character during that required time period. You mentioned 5 years for most and 3 years if married to a U.S. citizen. So during that period of time, if there is a crime, it may reflect on that person's moral character. And certain crimes would, by regulatory law, automatically result in a finding that that person lacks good moral character. And in that case, that person would be advised to wait until that crime is more than 5 years in the past and then apply for citizenship at a later time. The second way it might affect is certain crimes might result in a decision from the Immigration Service to refer that person to immigration court for a removal proceeding, a deportation proceeding. And that's why very special care should be taken to assess those risks.
Wow. So right at the top, Attorney, I was thinking, how does one with a criminal record along the way, again, prove that he has good moral character? Is there something else, something that they can do aside from waiting for 5 years?
Well, there are ways to show good moral character. There's a lot of ways to prove that you're a good person despite something that may have happened that resulted in a criminal conviction. People with criminal convictions are not necessarily bad people or lack good moral character. And if the crime is, let's say, relatively minor, or if even if it's not necessarily relatively minor, but there are significant positive equities like family ties, length of time in the United States, ownership of property, involvement in a church, volunteerism, other reasons why the Immigration Service might say, you know what, despite that crime, we're going to find that you have good moral character and grant your application.
How about those who are on probation? Can they apply for U.S. citizenship?
No. So there's a hard stop there. So if you're currently on probation or parole or you're under a suspended sentence, you've got to wait. So even though certain crimes don't necessarily disqualify an application, the Immigration Service will deny an application if the applicant is currently on probation or parole. Now, that doesn't mean that you have to finish probation and then wait 5 years, but you cannot be on probation when you apply.
Okay. And people have been asking us here at the radio station about deportation. So you mentioned it a little bit a while ago about deportation. Can anything be done if someone is on deportation proceedings already and they could eventually become, eligible to apply for naturalization?
Absolutely. And this is something that we take great care with at my office. If we've got somebody who comes to my office and they tell me that they want to apply for citizenship, but they've got a criminal record, I want to look at that record. I want to see what they were convicted of, when they were convicted of it. And I want to let them know what the probability is of a denial from the Immigration Service and a referral to immigration court. And if we go to court, what chances do we have in court? Now, just because there's a crime doesn't mean that that person gets deported. As a permanent residents, green card holders have rights, significant rights, substantial rights. And the law is designed to protect permanent residents from deportation if they can apply for certain waivers. So there's a few different waivers that we can look at depending on the crime and depending on when it happened. So the first is what's called 212C. 212C is just a section of the Immigration Act. It no longer exists. It was taken out of the Immigration and Nationality Act a very long time ago. But if that crime occurred before 1997, rather if the individual pled guilty before April 1st, 1997, then that relief is still available. 212C is a very good waiver because it does not require proof of hardship to a qualifying relative. It's a discretionary waiver. So essentially you show, you know what, I've got this old crime. I'm sorry for what I did. I'm rehabilitated. You can demonstrate that you've been a good person. You've tried to correct your life. And again, you got a showing of equities. You can win that relief. Another waiver that's available in court is called a 212H waiver. 212H waiver is the standard waiver. This is the waiver that in a lot of ways was meant to replace the 212C waiver. And 212H waiver does require a showing of hardship. And the 212H actually has two different waivers. One is for more recent crimes. More recent crimes require proof of extreme hardship to family members. And if the crime is more than 15 years old, all you have to prove is rehabilitation. And the last type of relief that we look at in immigration court, and this is not necessarily exclusive of all the relief that we can consider in immigration court, but another form of relief that is popular for permanent residents with criminal records is cancellation of removal. Cancellation of removal for permanent residents only requires that the individual has had the green card for at least 5 years, that they've lived in the U.S. for at least 7 years, and that the crime is not an aggravated felony. An aggravated felony is a specific type of crime as it's defined by the immigration laws. And if the crime that the individual is convicted of is not an aggravated felony, then cancellation of removal is a wonderful option. And relief in immigration court, in the perspective of the Immigration Service, is a way to kind of cleanse the record. So once that person leaves immigration court with relief, they can reapply for citizenship, and we would normally expect that application would be granted.
Great. Mga kababayan, a lot of information tonight from Attorney Eric Welsh. And for those who've just joined us tonight on Immigration Law on Your Side, we are talking about naturalization despite the fact that you have a criminal record. So stay tuned. We will be asking more questions. In the meantime, right now, Attorney Welsh is in... you're not in San Francisco right now, Attorney Welsh, right?
No, I'm down in Pasadena right now.
In the Pasadena office of Reeves Immigration Law Group. And at the start of the program, I failed to mention that you guys have a new office also at Walnut Creek. And Attorney Diza is always there. And for those who's looking for Attorney Flomi, he will be joining us pretty soon again here at PHLV Radio on Immigration Law on Your Side. In the meantime, we have Attorney Eric Welsh, partner at Reeves Immigration Law Group, based in Pasadena, California. Attorney Welsh, we're going to head over to a break. We are going to remind our friends how to contact you, especially now that we've given some bits of information about the topic that we're talking about. maybe they have questions already. So maybe they can call you and ask for guidance and set an appointment with you. So in the meantime, guys, we will be headed over to a break. When we come back, we are going to ask the question, are there any crimes that completely bar an applicant from naturalizing? Mainit na question ito mga kababayan. Sa pagbabalik po ng Immigration Law on Your Side, stay there.
Reeves Immigration Law Group has been representing immigrants for nearly 40 years. Reeves Immigration Law Group has been fighting for its clients through experience and expertise. With immigration lawyers you can access at reasonable fees, even on Saturday. Payment plans are also available. Call us for your immigration solutions. We can do worldwide telephone and Skype consultations. Reeves Immigration Law Group, 1-800-795-8009. Reeves Immigration Law Group has offices in Los Angeles, San Francisco, China, and Philippines. See us at www.rreeves.com. Reeves Immigration Law Group, 1-800-795-8009.
And like what we told you, they already have an office at Walnut Creek in California. Head over to www.rreeves.com or reevesimmigration.com for more details. And now we are coming back to Immigration Law on Your Side. Right here
Reeves
at
Immigration Law
PHLV
Group has
Radio.
been representing immigrants for nearly 4.
All right, welcome back to Immigration Law on Your Side right here at PHLV Radio. And we have tonight with us Attorney Eric Welsh, a partner at Reeves Immigration Law Group. He is based in Pasadena, California. Before we headed over to a break, we asked the question, are there any crimes that completely bar an applicant forever from naturalizing?
Unfortunately, yes, there is a class of crimes that are called aggravated felonies. And the reason that aggravated felonies bar an applicant is because the immigration law says that if a person is convicted of an aggravated felony, that person can never demonstrate good moral character. Now, that doesn't mean that person is a bad person. That just means that the law deems that person to lack good moral character for the purpose of applying for citizenship. So even if it has been a decade or 20 years, it doesn't make a difference. If there's an aggravated felony, that person is not going to be able to naturalize.
For the benefit of our listeners and viewers, Attorney, give us some examples of aggravated felonies.
Sure. So aggravated felony is a term of art, which means that you kind of have to throw out a common sense definition. It's not even necessarily a felony. It's certain crimes as they're defined by the Immigration Act, and those crimes include murder, rape, crimes of violence where the sentence is more than 1 year, theft offenses where the criminal sentence is more than 1 year, drug trafficking, and several other, I would say, significant crimes. So it's not typically, it's not typically a misdemeanor, although sometimes a state misdemeanor may fall within that list, which is why you really need to carefully navigate it. And also why it's important that anybody who has a criminal record who's considering applying for naturalization absolutely should consult with a lawyer to see what the risks are of going forward.
Now, speaking about consulting with a lawyer, Attorney Welsh, what would you advise someone who has a criminal record and still want to apply for citizenship or naturalization?
I think that person has to talk to a lawyer. And there's a lot of reasons why. Number one is because this is a complicated area and it's always changing. So some crimes, even, if a person pleads guilty to an offense and they have a defender who counsels them to plead, and maybe at the time that crime wouldn't be considered an aggravated felony or wouldn't be considered a crime of moral turpitude or a disqualifying offense. And then our case laws changed. So the courts interpret that crime to be the type of offense that falls within that definition. And that can happen after the conviction. So that's very aggravating, very frustrating for that individual who pleads guilty. And because of those complex changes that occur over time, it's important to have a good lawyer who's up to date with all of the current information to assess the criminal record. So if I have a client or a potential client who comes to me and they tell me they've got a criminal record, I want to see the complete record. I want to see everything from the court. I want to see the minute order. I want to see the complaint. I want to see the plea agreement. I want to see exactly what happened so I can help them navigate it as well as possible. And I would also like to say that just because a person has a crime, and even one like an aggravated felony that would potentially disqualify an application, there may be relief in criminal court to resolve that crime. So there's a whole body of criminal law called post-conviction relief. And post-conviction relief might actually, in a way, absolve that individual of the consequences of a criminal conviction if relief is available in criminal court. And I would say that's a topic for another day, because there are a lot of avenues for post-conviction relief. But that's also a good reason to talk to a lawyer.
That's amazing, and like what you said, that is probably a topic for another day. So we're going to have you back here again, Attorney Welsh at Immigration Law on your side. Well, at this point in time, guys, if you've just joined us, this is Immigration Law on your side, and we were talking about naturalization in the face of a criminal record. So how will you do that? You can just come back to this episode, download the podcast edition of Immigration Law on your side. Attorney Welsh, I'm going to give you the floor right now to address our audience, and if you wanted to say a shout out to anyone and tell us where to contact you, right there in Pasadena, California. Go ahead, sir.
Okay, great. Well, it's great to be here. I appreciate it. But I think this is really important. This is important stuff. The consequences are sometimes very serious, but the stakes are high because becoming a citizen is very important. So these things we don't want to say you're not eligible for citizenship, you can't do it. Don't shy away because you have a criminal record. Explore your options. Talk to a lawyer, because if it's important enough to you, it's important enough to us, and we'll fight for you.
Wonderful. Well, thank you so much, Attorney Eric Welsh. Once again, a partner at Reeves Immigration Law Group based in Pasadena, California. And they can they can look for you over at your website at www.rreeves.com or reevesimmigration.com. Again, Attorney Welsh, maraming salamat. I told you I was going to give you a few Filipino words for you to take home. So those words, maraming salamat, and also mabuhay. So all our audiences here at PHLV Radio saying mabuhay to you and salamat to you, Attorney Eric Welsh, for the wealth of information that you shared today right here at Immigration Law on your side. So we'll see you next time, guys, from PHLV Radio. This is Kuya Yo coming from Las Vegas. We'll see you next time, and hopefully with Attorney Eric Welsh again and Attorney Diza from Reeves Immigration Law Group. We will see you next time.
Reeves Immigration Law Group has just brought you Immigration Law on your side. Wednesdays, 7 p.m. Pacific on PHLV Radio.